Well, good morning, everyone. I'd like to begin by acknowledging the Ngunnawal people, the traditional owners of the land on which we gather today, and I pay my respects to your elders, past and present. I'd also like to acknowledge the important work of the United Nations Association of Australia under the leadership of Professor Russell Trood with his assistants Bill Banier and Harold Wilkinson. The importance of this organisation has been clear to me for more than 45 years of my professional career, and even before that as a student. I've always tried to come to these UN meetings, association meetings, if I possibly could, and it's such a wonderful experience to be in company where people actually understand the UN, are interested in it, and want to learn more about it. It's, of course, a rare privilege for me to be sharing the stage with Ban Ki-moon. I think it's wonderful that he's here with us. And I hope one day that will actually prove to be true in reality. Well, it's of course a great honour for me to be here with friends and colleagues to talk about a topic that as a public international lawyer has really been the inspiration for me from the very beginning of my career as a law student at the University of Melbourne in the early 60s. I always remember feeling rather out of place in a law school. I really didn't know about bankruptcy and constitutional law and torts and equity and contracts until I sat in the lectures of a marvellous man, Dr. Hans Leisser, who was a Polish Jew who came to Australia just before the Second World War. And I can always remember sitting in the front row. I was a bit of a goody-goody, I think, with my tartan skirt and twin satin pearls. But I listened to Dr. Leisser talking about the negotiation of the old covenant of the League of Nations, which you will all, of course, know about. And I can always remember him talking about the failure of the inspiration of that covenant when the tanks from Italy rolled into the then Abyssinia in 1936, and it was quite clear that the techniques of the covenant had failed. And I can always remember the tears rolling down his face as he described the extraordinary disappointment of the international legal community that the first attempts to ban the use of force was so obviously failing. But that, of course, brings us to the Universal Declaration of Human Rights and those enormously powerful words of Article 1, that all human beings are born free and equal in dignity and rights. It was the Universal Declaration, often referred to as the Magna Carta of our time, that forms the cornerstone of international human rights law, and in particular, as the ambassador has reminded us, that human rights are universal and inalienable. But also, I think, critical was the link in the Universal Declaration between peace and human rights. And it was clear after the Second World War that we were not going to have peace unless we acknowledged human rights as a critical phenomenon, as a critical element of our understanding of this law. The Universal Declaration consists of a preamble and 30 articles that outline the basic civil, political, economic, social, and cultural rights to which all humans are entitled, and states that human rights are to be enjoyed by all people, no matter who they are or where they live. Well, today I'd like to say a little bit about the influence of the Universal Declaration, but then to consider what I think is the most pressing challenge for contemporary human rights law, and that is to implement the principles of the Declaration in Australian law. The failure by most states to implement the human rights treaties to which they have willingly become party is one of the disappointments of the 20th century and one of the challenges of the 21st. But to begin at the beginning, the Universal Declaration of Human Rights was adopted 3 years after the end of the Second World War. It was a time when people were determined to create a rule of law-based institutional structure for peace, security, and an assurance that we can all live our lives free from violence and discrimination. The preamble begins by recognising that the inherent dignity of all members of the human family is the foundation for freedom, justice, and peace. The process of the debate and dialogue in the lead up to the adoption is significant in its own right. Before had such a diverse group of sovereign and equal nations come together to articulate the core values and traditions that define the fundamental rights and freedoms of their respective societies. It was a significant achievement for diverse and even conflicting political regimes, religious systems and values to find such common ground. The entire text of the Universal Declaration was negotiated in less than 2 years, something of a phenomenon by today's standard, and the drafting committee included Lebanon, the Union of Soviet Socialist Republics, China, France, the United States, the United Kingdom, Chile, Canada, and Australia. The Universal Declaration is a progressive reform document. For example, it sets out that everyone is entitled to all the rights and freedoms set forth in the Declaration, without distinction of any kind, such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status, which of course has left open the possibility for additional grounds of discrimination that have not been explicitly listed. And one that, of course, we're very alert to today is discrimination on the grounds of sexual discrimination and sexual orientation, amendments in relation to which the government has recently adopted. Once drafted, the General Assembly debated the document with the 58 member states, voting a total of 1,400 times on almost every word of every article. And you can see from this draft and the documents, when you look at them in the UN in New York, they really give you an idea of just what an arduous task this was. You couldn't do it with a word processor. You had to do it in this highly difficult way with the document, no fax machines, and it had to be copied or relayed in quite different ways. The text was adopted around midnight on December the 10th, 1948, and that, of course, is the United Nations Human Rights Day, and the day in which, in fact, the Australian Human Rights Commission celebrates and gives awards for community human rights. Well, I'm sure you're all familiar with the brilliant, but it must be said, somewhat testy Doc Evatt, who was the prominent figure in Australian politics during the middle of the 20th century. Prior to his work at the UN, he'd been a judge of the High Court of Australia, Chief Justice of New South Wales, and Attorney General. He was renowned for being an avid promoter of civil liberties and the rights of economically and socially disadvantaged people. And as Minister for External Affairs from 1941 to 49, he was the champion of the smaller nations, arguing against the veto power at all in the United Nations Charter. He was the powerhouse behind Australia's support for the Universal Declaration, and importantly was the President of the United Nations General Assembly at the time the Universal Declaration was unanimously adopted. And I don't think we can ever forget the highly personal nature of international politics and the importance of this man in making sure that this declaration went through formally. That's quite a formal letter of him signing the UN Charter, but I have another photograph that I didn't bring today, partly because we're in caretaker mode and I don't want to do anything that's even remotely controversial. But I do have a lovely photograph of Doc Evatt looking totally shambolic, possibly after midnight, but before the signing of the declaration, where the United States ambassador is straightening his tie and fixing his shoulder pads in his coat to try to smarten him up for the cameras. It was either a friendly act or a deeply patronising one, but we'll take the former. But he must have been an extremely interesting man, and I don't know whether you've read the Kylie Tennant biography of Evatt, but that's one of the few biographies I've ever read where I've been in tears at the end of it. He really was the most interesting and inspirational man. Well, the point that I really want to make is that we've seen an extraordinary development of international, regional and bilateral human rights treaty law based on this Universal Declaration. We've seen a growth of legal jurisprudence through the United Nations monitoring bodies and, of course, through regional, international and national courts. So the Declaration has had impact, not only legally, but it provides a moral and political force. It's established a common language around human rights. Remarkably, the document is currently available in 407 different languages, making it the most translated document in the world. I was astonished by that statistic. And the Office of the High Commissioner for Human Rights has been awarded the Guinness World of Records for having collected, translated, and disseminating the Declaration. So I think Doc Evatt would be very pleased with the influence that that Declaration has had over nearly 65 years. Well, it is, of course, the 20th anniversary of the World Conference on Human Rights held in Vienna, where the World Conference has rejuvenated the human rights work of the UN and revived the importance of the Universal Declaration. And it was at that conference that 171 countries reiterated the universality, indivisibility, and interdependence of human rights and reaffirmed their commitment to the Universal Declaration, adopting the Vienna Declaration and Programme of Action, which has provided a new framework for planning, dialogue, cooperation, and which has established the Office of the UN High Commissioner for the Protection of Human Rights. It was also at this conference that the unique and important role of national human rights institutions was recognised as independent protectors and promoters of human rights. Since 1992, we've witnessed an exponential growth in the number of national human rights institutions. They now are to be found in 103 countries, potentially 193. And of these, 69 are currently credited with A status under the Paris Principles, including, I'm very pleased to say, the Australian Human Rights Commission, that I'll speak about a little later. But the question that's dogged consideration of the Universal Declaration is, what is its legal status? The Declaration was drafted as an expression of the fundamental values and principles shared by all members of the international community. It's not a treaty, so it doesn't create direct obligations for countries. And Eleanor Roosevelt, went to some pains to say at the adoption, in giving our approval to the Declaration today, it's of primary importance that we keep clearly in mind the basic character of the document. It's not a treaty, it's not an international agreement, it is not and does not purport to be a statement of law or legal obligation. Well, much as I greatly respect Eleanor Roosevelt, I rather wish she hadn't said that. Because, of course, in my view, as an international lawyer, many of the articles of the Declaration have achieved the status of customary international law. Now, I have to concede that that's not a universal view. Not everybody agrees with my view, but I think my view is certainly supported by many. But the area that, of course, is of greatest concern to me as President of the Australian Human Rights Commission is that very important Article 14 of the Universal Declaration. And you might remember, of course, that that is where it is first stated, in 1948, before the Refugees Convention, that there is a right of all persons to claim asylum from persecution. Now, the curious phenomenon has been that that Article 14 was never translated into the Refugees Convention, nor into any other major document. So, given that this is a matter that takes a great deal of my time, as I'm sure you can understand, it's very much critical to the kinds of arguments that we make to governments in relation to asylum seeker policy, that this concept of the right to claim asylum in the Universal Declaration now reflects customary international law. But equally, I know that many of my colleagues, including in UNHCR, are not so sure about that, so we do have to be a little careful. But it's an example of a profound problem, and that is to what extent does this declaration now, through customary principles, come to reflect the basic principles of international human rights law. Well, we do know, of course, that the Universal Declaration has been the foundation for many other more sophisticated, if you like, international human rights agreements, most particularly, of course, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, both of which refer explicitly to the Universal Declaration in their preambles. These covenants are, of course, legally binding, and they do form what is really a form of international Bill of Rights. But I do find, again referring back to my position with the Human Rights Commission, that obviously it doesn't gel or have traction with a wider public if I start to talk about specific provisions of the international covenants. That really does sort of go over people's heads. And what I find as a practical matter is that I'm frequently going back to the core principles of the Universal Declaration, because those are the principles that people readily understand and can relate to. When, for example, we were thinking about a Commission position on marriage equality, we referred back to the core principles of this declaration in relation to equality of all human beings. So I've actually found it rather more useful in this job than I did in my earlier positions dealing with either commercial international law or in my academic career. Today, it's interesting that all UN member states have ratified at least one of the 9 core international human rights treaties that have depended on the declaration, and 80% have ratified 4 or more. While more work needs to be done to encourage ratification, particularly within the Asia-Pacific region, this, I think, is a welcome and a very significant commitment to the ideals of the Universal Declaration. Many scholars do accept its customary law status, and I think one can make a very strong argument for that based on an examination of the jurisprudence of the International Court of Justice, particularly in the advisory opinion on nuclear weapons, and in the hostages case, the UN-Iran hostages case, where the ICJ referred directly to the Universal Declaration and found its fundamental principles proof of the existence of universal human rights. There, the court said that wrongfully to deprive human beings of their freedom and to subject them to physical constraint in conditions of hardship is in itself manifestly incompatible with the principles of the Charter and of the fundamental principles enunciated in the Universal Declaration. But why then is the legal status, or am I concerned about the legal status of the Universal Declaration as a matter of customary international law? Why is it an important question? And the answer lies in the need to implement the Declaration and the treaties that build on it through the national measures of implementation. Early in 2005, the Secretary General of the UN, Kofi Annan, released a report that set out his vision of the United Nations for the future, called In Larger Freedom. And he pointed out that when it comes to laws on the books at the international level, no generation has inherited the riches that we have. We're blessed with what amounts to an international Bill of Rights, among which are impressive norms to protect the weakest among us. But without implementation, our declarations ring hollow. Without action, our promises are meaningless. The time has come for governments to be held to account, both to their citizens and to each other, for respect of the dignity of the individual, to which they too often pay only lip service. We must move to an era of legislation and to an era of implementation. Well, sadly, many nations are happy to parade on the international stage and to sign up to human rights treaties surrounded by flashing cameras and global celebrities. But when their diplomats return home, they face the long-term impediment that under most constitutional systems, treaties have no national impact unless they've been implemented by legislation duly passed by Parliament. This principle, of course, reflects the democratic principle of parliamentary sovereignty. So what's the position in Australia? Australia is unique among comparable legal systems in that it has no explicit constitutional protections for most human rights and no Human Rights Act at all. The Australian Constitution deals with human rights in what has been described as an incoherent patchwork, so that the executive and parliaments, rather than our courts, have had the primary responsibility for restricting or protecting our human rights. The Constitution guarantees some human rights in narrow respects only, for example, the implied freedom of political communication. But most of our judges see themselves as largely restricted to statutory interpretation when applying common law protections. It's therefore somewhat paradoxical, and something perhaps we need to think about, that while the Australian Constitution and laws do not explicitly protect many of our rights, for example, freedom of speech other than the implied freedom, we have a robust culture that demands this fundamental freedom be protected and respected. The Australian courts have adopted the principle that any treaty to which we become party has no direct or binding effect on Australian law until it's been the subject of legislation. Moreover, where an international rule becomes custom, our courts have also seen that customary international law cannot be incorporated automatically without legislative transformation. There are some flexibilities in this. Justice Brennan, in Marbo's case, stated that international custom can inform the common law, and other judges have agreed with that view. In the very important decision of the High Court in Teo's case, it was decided that Australians have a legitimate expectation that government officials should at least take into account the treaties to which Australia is a party, even where they've not been implemented in domestic law. A primary example in that case, of course, was the Convention on the Rights of the Child. But I think despite that dicta, and we haven't seen much practical implementation of that dicta, we have a rather unique approach to the implementation of laws in Australia through administrative processes and through very precise pieces of legislation. We do, of course, have the Australian Human Rights Commission Act, which underpins the Human Rights Commission, obviously, but we also have very particular legislation that sets up the bases for our 6 commissioners. One is the Race Discrimination Act, the first to implement that international convention, and you might have noticed that the attorney has just appointed Dr. Tim Soutphommasane as our first, as our new Race Discrimination Commissioner after a gap of some months. We also have Mick Gooder, who is our Social Justice Commissioner under the terms of the Australian Human Rights Commission Act. Liz Broderick, the Commissioner under the Sex Discrimination Act, giving effect to CEDAW. Graham Innes, giving effect to the Disability Discrimination Convention under that legislation in '92. And Susan Ryan, the former Labor member of Cabinet during the Hawke years, is now, of course, our Age Discrimination Commissioner. This is the one piece of legislation that doesn't have an international convention. Then we have a recent appointment of Megan Mitchell as the Commissioner for Children, again by reference to the Convention on the Rights of the Child. We also have very particular human rights responsibilities under certain treaties, the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child. But now we come to the core legal problem that I really wanted to emphasise, and one that dogs our efforts to implement and monitor human rights in Australia, because these treaties are not implemented in Australian law. So, for example, the failure to implement the International Covenant on Civil and Political Rights presents a significant practical impediment to the work of the Commission. For example, when I have advised government that mandatory detention of asylum seekers runs the risk of breaching the obligation under Article 9 of the International Covenant on Civil and Political Rights that prohibits arbitrary detention, the relevant government department, DIAC, responds that the policy conforms to the Migration Act as amended, and that the International Covenant on Civil and Political Rights does not have direct application in Australia. It informs the definition of human rights for the purposes of the Human Rights Commission. But apart from advising governments or government officials or the Australian community, we can't do anything more with that convention because it's not part of our law directly. Compounding the problem is that we also don't have jurisdiction with respect to the International Covenant on Economic and Social Rights, nor under the Convention Against Torture, and the Convention in relation to the rights of the child is similarly not part of Australian law. These are the specific recognised bases of our jurisdiction, but again, with the exception of the rights in relation to disabilities and some in respect of the work employment rights under the ILO conventions, none of these is directly enforceable in Australian law. So that you can see that we do have a very significant practical problem in giving effect to the international human rights law that was based on the Universal Declaration. But rather more positively, we do have several statutory functions. We accept and try to resolve by conciliation individual complaints. We have about 17,000 inquiries and complaints a year, and you might be interested to know that you can't go to the federal court in relation to our legislation, in relation to these acts, unless you go through the Commission first. which gives a very strong anti-discrimination focus to the work of the Commission, because the other international treaties are not part of domestic law. I'm very pleased to say that it is, however, a very successful process, and I'm really rather proud of that aspect of what the Commission does, because we managed to conciliate about 65% of these complaints, and I think we give a genuine access to justice to people who otherwise wouldn't be going anywhere near our courts. And of those that we don't settle or conciliate, only 3 or 4 a year ever go to the federal courts. So without cost to either complainant or respondent, we do manage to provide some human rights basis on which conciliation of human rights complaints can be managed. We also intervene in court proceedings that involve human rights. And we've recently intervened, for example, in the case of children in adult prison facilities in Western Australia. We intervened in the Maloney case that concerned the Queensland liquor laws on Palm Island that criminalised the possession of alcohol, and we have done in many, many cases that have come before the family court. I mention these interventions because they've become a very interesting way in which human rights can get before our courts. So even though our courts could not directly enforce the International Covenant on Civil and Political Rights or the Convention on the Rights of the Child. So as a lawyer, you can't go to the court holding those treaties aloft and saying to the judge, you should enforce these provisions. Although that can't happen, it's possible to come into those courts through the intervention of the Human Rights Commission, where we argue for the foundational principles that, again, come home to the Universal Declaration. What's been interesting in the last few years, and I've noticed it obviously in the last year in particular, that the courts are speaking very favourably about the interventions that the staff of the Commission have made, and the barristers who typically appear for us pro bono, I should say, for which we're of course immensely grateful. But the courts are usually very happy to have us intervene, and not infrequently cite word for word the recommendations and law that we've been promoting. So we do have a very unusual system, and one that does work quite effectively in most areas of human rights enforcement, but not in ways that, of course, it works in most other comparable countries, particularly common law countries, where they have human rights acts or constitutional provisions. We also conduct research and propose new policy and standards which will promote the enjoyment of human rights. And we've just done, through Liz Broderick, a major piece of work on sexual abuse in the military. And we've done, through Susan Ryan, some important basic research on age discrimination, which, as I approach this magical age, I'm becoming increasingly aware of the extent to which Australians are subject to discrimination on the grounds of age, particularly insurance and workers' comp matters. Another area is that we can and have the power independently, because we are an independent statutory body, to bring inquiries. We try not to abuse that right, but we did have one done by my predecessor, Catherine Branson, formerly of the Federal Court, on the use of wrist x-rays to determine the age of Indonesian children who came across as asylum seekers or as crew, believe it or not, of people smugglers. What was interesting about that, and one reason I particularly mention it, is it's an example of how one can work productively with government in these areas, because Catherine started this inquiry, and the government was at that stage wedded to its wrist x-ray technology to determine the age of children or adults, as the case may be. But as the evidence became clear that this was very imprecise technology, the government started to work with the Commission, so that before the report was actually finally produced, the government had already changed its policy and no longer uses the wrist x-ray technology to make definitive determinations about these children. So it can be a very, very effective means of achieving change, and in many areas governments do indeed listen to what we are arguing. But of course, you won't be surprised, at least in relation to my background, that one of the things that we place an enormous emphasis on is education about human rights to improve awareness and understanding. And we now use the social media to a very high degree, and we've been using video clips to get our message across. One is a marvellous hip-hop video. You can look it up on our website. by Brother Black from James Mitchell School in Western Sydney. This is an Indigenous Australian who is a hip-hop singer, and he worked with the students of that school to produce a really quite catchy song. I think we need to get it across to the media more widely, actually, and get it out there. But it's a very, very powerful message about internet bullying, homophobia in the classroom, and general racism in our schools, something that before I took this job I really wasn't aware of the extent to which this actually goes on, and it will be an area of concern for us. So we are using video clips, getting young students to use their iPhones to make video clips about these issues. But also, of course, we're finding the general public are sending their iPhone video clips to us to demonstrate exactly where we see racial abuse, for example, in our public transport. We also work very strongly through the United Nations framework, and particularly through the Universal Periodic Review, which has proved to be extremely successful. Australia has had its first accounting, if you like, before the Universal Periodic Review, and Australia accepted more than 90% of the recommendations that were made. So coming back from the international to the domestic and back to the international, there are increasing mechanisms by which we have scrutiny of Australia's human rights and the extent to which we comply with the Universal Declaration. And one of them, and perhaps not really known as well as it might be in Australia, is the creation in 2012 of the Parliamentary Joint Committee on Human Rights. It's described as the Scrutiny Committee. It's been in operation now for over a year. It was chaired by Harry Jenkins, the former Speaker of the House, and it's really been an extraordinarily successful mechanism for administrative parliamentary scrutiny. Now, it's not everything a human rights lawyer would want. We haven't got a Bill of Rights. We don't have constitutional provisions in the main. We haven't got legislation. But this Scrutiny Committee takes what might be seen as a particularly Australian approach to human rights protection, and that is it's done through the sovereignty of Parliament. And this committee, under Mr. Jenkins's leadership, has in fact has examined scores of bills, and it has, I'm very pleased to say, agreed almost invariably with the submissions that the Human Rights Commission has made. So the next question, and the difficult one, is going to be to what extent will government of the day take account of the findings of the Scrutiny Committee? And I can say that in relation to migration policy and asylum seeker issues, the Scrutiny Committee produced a report that was bipartisan. There was no dissenting report. So it was a bipartisan report that agreed with the submissions that we have made on migration policy and asylum seeker issues. Now, that's a pretty strong statement, not only from the National Human Rights Institution, but most particularly from a joint parliamentary body without a dissenting report. But that has thus far been ignored. However, I'm hoping that in the future, we will find governments more willing to take account and notice of that scrutiny body. Now, I will conclude. I've more than used my time, but I did want at least then to reaffirm, as a matter of law and influence and practice, the Universal Declaration has had an extraordinary influence on the development of international human rights law. It's used and referred to frequently. Although its original intention was not to create legal duties, it has provided a common understanding of human dignity and values, and I think played a pivotal role in fostering a common language about human rights and how they apply to everyday life. And this, I believe, is its enduring achievement, and I thank you all very much indeed for listening to me. Thank you.